Thanks. It's a pleasure to be here. I've been asked to address the question, are pro-corporate decisions hurting everyday Americans? And the answer is absolutely yes. And in particular, I look at the area of procedure. There's definitely a pro-corporate lean out of decisions coming out of the Supreme Court that hurt everyday Americans. When we think about the rules of procedure, right, they're just neutral. We're thinking the Supreme Court is interpreting neutral rules, but in fact, they have a negative impact on consumers and employees every day. Now, I'm going to address some procedural issues. I know for many people, your eyes may glaze over. People think it's time to take a nap. But I really want people to focus because these kinds of cases really do matter in terms of their impact on people every day. One of the biggest issues that we see coming out of the Supreme Court is access to justice, or just access to the court system in general, or the courthouse, as we might say. And there's really if you look at the Constitution, we have a due process concern that people have their right to their day in court, right? That is sort of a fundamental notion in our judicial system. And the basic idea here is it's becoming harder and harder for people to have their day in court or to actually have access to the system. And it's basically happening in three different ways. We see, first of all, can you just get your case not to be dismissed, right? The pleading standard. What are the requirements for filing a lawsuit? And that comes, we've heard of the Supreme Court cases, Twombly and Iqbal. Second of all, once you do survive dismissal, can you get a judge to hear your case, or are you going to be forced to have an arbitrator instead listen to resolve the dispute? And finally, if you survive all that, are you going to be able to bring your case as a class action? Can you collectively come together with other people who are similarly situated? You have small claims, you don't have a lot of money. Will you be able to pool your resources in a way that gives you strength to challenge corporate misconduct? So we have all of these areas are important, and we're seeing a problematic trend coming out of the Supreme Court where access to justice is compromised. And I think it's an important thing to make the connection between what seem like very technical procedural issues and the notion of justice, because they really do go together in ways that I think people are sort of can miss if they're not paying attention. First of all, getting your case just heard, right? Getting through the door. We know that there are two major Supreme Court cases that have come out: the Bell Atlantic versus Twombly case, the big antitrust class action out of 2007, and then the Ashcroft versus Iqbal, which came out in 2009, following the 9/11 terrorist attack, and dealing with the question of whether or not people who were detained, whether or not those people were targeted because of race, religion, or national origin. Now, we can talk more about those, but the problem that came out of those cases is that you have federal rules. The federal rules, they're supposed to apply across the board to all cases equally, whether you're bringing a civil rights case, a consumer case, environmental case, contracts, whatever. But we know that that's not what's happening, that these cases are having a disproportionately negative impact on certain types of cases and certain types of plaintiffs, like consumers and people who are challenging violations, corporate misconduct, maybe their employers, and so forth. And that's because the standard has changed. It has elevated. Back before these cases, we knew if you had a case, you put facts in your complaint that would enable your case to survive. And you would have to do this before discovery. Discovery is that whole process where you have a right to force the other side to give you information that's relevant to the case. But that stage comes later, after you file your lawsuit. And that was the way it went. You bring your case, and the facts may show it could have been legal conduct, it could have been illegal conduct, could have gone either way, right? We don't know, we can't know until we get into the discovery process. Well, that's all changed. Now the court has elevated that standard and made it much more difficult for employees, consumers, and others who are challenging corporate misconduct to go forward without having their complaint dismissed, because they can't get access to that information. They can't actually get into discovery. And that's particularly difficult for people who are challenging issues like intentional discriminations or state of mind. You can't know what the other side, what they were thinking unless you're able to depose that person and get that information. You're not going to have access to company-wide documents, policies, statistics until you can get into that discovery process. And so the senator, I think, raised a good example was the Lilly Ledbetter case. When you think of Lilly Ledbetter, there was no way she was going to know about, she was being underpaid for years and years and years. That's why she missed the statute of limitations. So that kind of information is clearly something in the hands of the employer or the corporation and not in the hands of the individual. So you've got to be able to have access to the discovery process. And unfortunately, that is no longer happening for certain types of cases. It's taking, I think, employment cases, consumer cases, antitrust cases are taking a hit when it comes to being vulnerable and being dismissed early on. All right, so let's assume that your case does survive dismissal. Next issue is, can you have your case actually heard by a judge, or are you going to be forced to have your case heard by an arbitrator? Now, this is a significant trend. We see a lot of arbitration agreements have cropped up, which require sort of everyday Americans. You want to have anything, right? If you want a bank account, you want a mortgage, you want a cell phone, you want a job. I mean, we see this in all kinds of consumer agreements. Then you're going to see a clause that says, if you have a dispute with the lender or the employer, whomever, in the future, then you give up your right to have a judge resolve that dispute, and you have to have an arbitrator make that decision instead. And so these are proliferating in contracts all over. And the Supreme Court the last couple of decades has deferred to enforcement of those agreements. All right, and that has been the trend all along. Why do we care about that? What's the issue here, the due process or the access process here? Well, we know that mandatory arbitration, there are times when arbitration can be very good, right? You have an alternative dispute resolution where you're able to sit down. Maybe it's going to be faster, maybe it will be cheaper, maybe it'll be more flexible or informal way of resolving a dispute. So that may be the case, but the issue here is consent, right? Whether or not you are consenting to that arrangement. Back in the day, it made sense for the Supreme Court to defer. Thank you. To defer to these kinds of agreements because it was in the context of collective bargaining, right? So Bill knows a lot about this, but I mean, if you had an employer and a union who were equal players, then it made sense for them to negotiate the terms of some kind of employment agreement. Here, we don't have too sophisticated bargaining, people of equal bargaining power. In fact, you might have a consumer or an employee, somebody who's challenging some kind of corporate misconduct, and they have no way of actually negotiating. And let's take that arbitration agreement out of the contract, right? I know it doesn't work. I've tried, right? If you try with your bank account or whatever to scratch that out, there's no negotiating. It's a take it or leave it contract. So those are the terms that you live with. And what's problematic is people don't realize not only can arbitration be good, but it's got other side effects, right? There are other kinds of attributes where you may not get you don't get a jury trial, right? And this is something I think the senator mentioned, which is very important. You don't have access to a jury. You may have limited discovery. You have limited appellate review. And now one of the big issues is you may not be able to get a class action within the context of arbitration. So you sign something, and we see a proliferation of these class action bans in arbitration. And this is specifically what's at issue in AT&T versus Concepcion. And the class action sort of brings me to my last point here is, why is that important? Why do we care about class actions? Well, certainly in the AT&T versus Concepcion case, the issue is whether or not the class action ban is basically immunizing corporations from liability by not letting people pursue the class action. Class action is one of the most important mechanisms that consumers and everyday Americans have for challenging corporate misconduct. It is one of the few effective ways that you can actually do that, because people with small claims, people who don't have a lot of resources, can pull that together, and there's strength in numbers in terms of challenging that. We know that it's certainly efficient rather than having many cases over and over and over that look the same be litigated, we can have it resolved all within the context of the class action. And we know that in terms of agency enforcement, sometimes the agency that's tasked with enforcement may not have the resources or even the political will to push some of those cases. So let me just end in saying that and this is the Walmart case, really, which we'll have a chance to talk about hopefully more. But the Walmart case is critical because it does threaten the availability of the class action, which is the really only effective way to challenge systemic corporate misconduct. And so if we look at procedural decisions, absolutely they are impacting everyday Americans in a very negative way. Thank you.